Greetings to all. Welcome to Future Officers Academy. Today we are going to see the daily current affairs of 3rd May 2024. To get more daily current affairs videos, follow our YouTube channel, also our Telegram channel. Now we'll move on to the topics. Today we are going to see all these topics. The first topic is online gaming, and the next is new criminal laws, and the third is center-state relations, and fourth is PM Arogya Yojana, which has been come in our editorial session of today. Here, what is online gaming? The practice of engaging in gambling activities via internet is known as online gaming. It entails putting money on other prizes at risk on a variety of games and events through the bets and wagers. It can be played on the variety of gadgets such as laptops, tablets, smartphones and PCs, and it uses virtual chips or digital currencies in place of real money. The size of the world market for online gambling was estimated at $63.53 billion in 2022, and between 2023 and 2030 it is projected to expand at a compound annual growth rate of 11.7%. With China and Japan making up the majority of the market, the Asia Pacific area is home to the largest online gambling market. The most nations, including India, online gambling is governed by laws and prohibitions that vary in severity. We have major types on this online gaming, like as casino games, sports betting, poker, lottery. And what are all the challenges seen in this online gaming? It leads to addiction, because of online gambling is so accessible and players can lose hours to games without realizing how much money and time they are spending. Next, lack of regulation. Since online gambling is frequently unregulated, fraud is easily committed. Next, underage gambling. Underage gambling is a result of kids having easy access to online gaming sites. Children and their families may have serious financial and psychological difficulties as the result. Next, money laundering. Players can deposit significant sums of money into their online accounts and subsequently withdraw the money in a legal manner, making internet gambling a potential conduit for money laundering. Next, cybersecurity. Cyber attack can compromise online gambling sites, allowing players sensitive financial and personal data to be stolen. Then, social isolation. Because gamers might spend hours playing games online and without interacting with friends and family, internet gambling can result in social isolation. Next, what are the advantages seen in this online gambling? The advantages is accessible entertainment, also a revenue generation, tourism, responsible gambling, and laws governing online gambling. Now we'll say about laws governing online gambling. Which are the laws governs that online gambling? India has complicated legal system for online gambling that varies from state to state, although there are some general regulations that apply to the whole nation. The first one is Public Gambling Act 1867. It is against federal law to run a gaming establishment or to go there. Internet gambling is not expressly mentioned in this regulation. The next one is Information Technology Act 2011. It says the internet gambling clauses which stipulate that any website offering online gambling service must be based on outside of India were added when it's revised. Many Indian states have their own gambling regulations and others like Goa and Sikkim had made some types of gambling legal and granted operation license. And there are some judgments which related to online gambling. The first is Dr. K.R. Lakshmanan versus State of Tamil Nadu. It was held in 1996. The Public Gambling Act 1867 does not classify games of skill like rummy and horse racing as gambling, according to the ruling of Supreme Court of India. In this case, they have said about this. The next is State of Andhra Pradesh versus K. Satyanarayana in 1968. In Andhra Pradesh, High Court playing rummy for money is forbidden since it's seen as gambling. Like this, we have some of the judgments. Here, our next topic is new criminal laws. After abandoning the earlier versions, the Parliament enacted three amendment criminal law bills during the winter session to replace the current British era criminal status. To know about these criminal laws, we have to know a brief history of criminal laws. First, we'll see in ancient India. In ancient India, we have Dharma Shastras and Artha Shastra. In Dharma Shastra, it says about old legal writings like Manusmriti outline moral and ethical standards. These writings addressed social and moral behavior as the criminal sanctions. In Artha Shastra, it says about guidelines for administration of justice, punishment, and law enforcement during the Mauryan era, which was written by Chanakya. Next, in medieval period, we could find Islamic influence, which criminal laws in areas ruled by Muslims were impacted by Sharia legal system after the establishment of Islamic authority. Qazis used Islamic jurisprudence to decide criminal cases. Hindu-Muslim legal synthesis. In regions where both communities coexisted, Hindu and Islamic legal ideas were synthesized. In colonial era, we could find Regulating Act of 1773, which says Indian Company introduced English law and established courts to handle legal matters in Indian Penal Code IPC, Code of Criminal Procedure 1898. And in post-independence period, we have Constitution of India 1950 and amendments and new legislation are seen under this. What are these? The IPC and CRPC have undergone modifications over time to reflect shifting societal demands. To address new issues, new laws have been passed, such as Prevention of Corruption Act and Narcotic Drugs and Psychotropic Substance Act 1985. Now, what are the recent reforms seen in this new criminal laws? The first is Criminal Law Amendment Act 2013. It says this was passed in reaction to Nirbhaya's case, reinforced the rules pertaining to sexual offences by adding new offence and stifling Penalties Act of 2015 for juvenile justice, care and protection of children. This law seeks to protect and rehabilitate minors who are in trouble with the law by addressing offences committed by juveniles. The next is Criminal Law Amendment Act 2018. It says that tougher rules for offences against women and children. Then Bharatiya Nyaya Second Sanhitya. Bharatiya Nyaya Second Sanhita 2023. In this, the principal law on criminal offences in India, offences covered including those affecting human bodies such as assault and murder, property such as extortion and theft, public order such as unlawful assembly and rioting, public health, safety, decency, morality, and religion, defamation, and offences against the state. These are the recent reforms seen in new criminal laws. The next topic is center-state relations. The federal systems of Indian Constitution allocates all legislative, executive and financial authority to center and states. There is no separation of powers in judiciary since the Constitution created a single unified judicial system to enforce both federal and state laws. The federal system requires the highest level of harmony and collaboration between the federal government and the states, despite the fact that each is a leader in its own right. Now, what we have to know about center-state relations? We have relations on legislative, administration, finance. In these all things, we have in these legislative, administration, and finance. In the control over the state legislation, we could see four aspects in that: territorial extent of central and state legislation, distribution of legislative subjects, parliamentary legislation in the state field, and center's control over the state legislation. Also, the parliament has the authority to enact laws that apply to all or part of Indian territories. State legislatures can enact laws that apply to a state's entire territory or just a portion of it. State laws do not apply outside of the state unless there is a substantial relationship between the state and the object. Parliament is the only body that can enact extraterritorial laws. Now, what are the administration relations? The federal government and states share an executive branch as a result of division of legislative responsibility. The administrative relationship between the center and the state is covered under the Article 256 to 263 of the Constitution. Here we have some of the executive powers related to the administration. When it comes to the matters, the exclusive jurisdiction as well as when it is exercised any rights, jurisdiction or authority granted to it by convention or agreement. The state has jurisdiction over the topic specified in the state list. The next is financial relations. The Constitution has Article 268 through 293 addresses the financial relationship between center and the state. The next is PM Jan Arogya Yojana. What is Ayushman Bharat PM Jan Arogya Yojana? The largest health insurance program in the world is wholly funded by the government alone. It was introduced in 2018 and provides family with a maximum insured amount of rupees 5 lakhs. For the secondary and tertiary care, health benefit packages pay for test, medication, surgery, medical care, and nursery expenses. Who are the beneficiaries of this scheme are the beneficiaries entitled based program of those determined by the most recent social economic caste census statistics. States and union territories now have the option to tag remaining families against database of non-social economic caste census recipient families that have comparable social economic futures. Now, who have been funded this? The program is funded in the following portions of 100% central amount. For union territory without a legislature, it has 100% and 90% for northeastern states, Jammu Kashmir and Himachal Pradesh, Uttarakhand, and 60 to 40 ratio for all states and union territories with their own legislation. 100% with union territories without legislature, 90% for northeastern states, Jammu Kashmir, Himachal and Uttarakhand, and 60 to 40 ratio is for all states and union territories with their own legislature. Who are the nodal agency for this? Under the Society Registration Act 1860, the National Health Authority was established as the independent body to carry out the scheme in cooperation with state governments. The state government's highest authority, the State Health Agency, is the charge of implementing the scheme throughout the state. Here, empaneled hospitals, nearly 43% private and remaining public. Belief of private sector delivers better services. In most places, the private hospital gives better and quality care. In many states, the number of people per empaneled healthcare provider is really high. There is no adequate number of beds and other facilities. Delay in claiming payments are also seen in this. Rejection in claims also seen. That is treatment or surgery they claim for insurance is rejected for any reason. Also, governments lap on the amount charged for the different treatments. These are the reasons for the private hospitals turn away to take at fewer patients. The public sector should be strengthened and lower the people per empaneled hospitals to deliver this scheme more efficiently. Inactive hospitals for seen largely. For example, in UP, 39% of hospitals are inactive in last 6 months. Difference in dispersion of hospitals between states is seen. Delay in claiming payments also seen. The main reason is that inadequacy of hospitals in some states, especially in northern and northeastern states. It is too much to include outpatients and drugs under this scheme. Also, in other states, schemes taking care of the medicines. This scheme is designed to take care of healthcare shocks. The inpatient treatments can cost higher than the outpatient. This scheme is not only reducing out-of-pocket expenditure but also gives quality care. In some states, it is the only source. By improving the public sector in healthcare systems, more can get benefits. That's all from today's topics. To get this PDF download, the link will be provided in our description and you can download it from our Telegram channel. To get more daily current affairs videos, follow our channel. Thank you.